Welcome to Module 14, Data Protection Act 2018. This module details the relationship between the EU General Data Protection Regulation and the UK Data Protection Act 2018. At the end of this module, you will understand why we have a Data Protection Act, how the DPA and GDPR are linked, the differences between the DPA and GDPR, the different data protection regimes outlined in the DPA, how the DPA is enforced, and the effect of Brexit on personal data transfers between the UK and the EU. The Data Protection Act, History. Since the Second World War there have been a number of attempts to formalize data privacy within the European Union. It was only with the advent of the EU Data Protection Directive 1995 that there was a unified approach. However, the directive could be interpreted differently in each EU jurisdiction, so the EU General Data Protection Regulation, GDPR, 2016, was introduced to minimize the differences. The UK initially introduced the Data Protection Act, DPA, 1998, to reflect the EU directive, and subsequently the DPA 2018, to reflect the GDPR. The General Data Protection Regulation, GDPR. The GDPR regulates the collection, storage, and use of personal data significantly more strictly than the earlier Data Protection Directive. As it is a regulation, it applies across the whole of the European Union, and must be applied as it is written. However, the GDPR has a number of derogations, allowable changes, which can be applied by member states. Each jurisdiction has created its own Data Protection Act, which fulfills the requirements of the GDPR, and highlights where variation due to the application of a derogation applies. The Data Protection Act 2018. The DPA sets out the framework for data protection law in the UK. The DPA embodies the EU General Data Protection Regulation, but tailors how it applies in the UK. It extends data protection laws to areas which are not covered by the GDPR. It states the exemptions, derogations, applied that are permitted by the GDPR. It also sets out separate data protection rules for law enforcement authorities, extends data protection to some other areas such as national security and defense, and sets out the Information Commissioner's functions and powers. The Act is split into 4 parts, setting out 4 separate data protection regimes. General Processing, GDPR. General Processing, Applied GDPR. Law Enforcement Processing, and Intelligence Services Processing. Why is the Data Protection Act 2018 based on the GDPR? Since a large proportion of UK business involves data transfers with the EU, it makes sense for the UK to adhere to the majority of elements of the GDPR. The GDPR has very strict rules around the international transfer of personal data, which the UK needs to adhere to, and it's currently the global standard and the basis for many other data protection laws. Key elements of the DPA 2018 and GDPR. The DPA 2018 and GDPR have many common elements, although these may be interpreted differently. These include principles relating to the processing of personal data, rights of the data subject, security of processing, international data transfers, management of data breaches. Differences between the DPA 2018 and GDPR. There are a number of differences between the DPA and GDPR, including the use of sensitive data by some agencies, the use of immigration data, exceptions to the use of automated processing, law enforcement processing, and intelligence service processing. Scope of the Data Protection Act 2018. Neither the Data Protection Act nor the GDPR apply to individuals using personal data for personal or household use. For example, schools may allow parents to film a Christmas play as long as the resulting footage is kept by the child's family and is not posted on social media platforms. Application of the four data protection regimes. In practice, most organizations will be concerned with only the two general processing regimes, which are intended to operate in a very similar manner. The other two regimes apply to a limited group of controllers, law enforcement, and the intelligence services. Individuals may of course be affected by processing which is regulated under any one of the four regimes. Regime 1. General Processing, GDPR. If the processing is subject to the requirements of the GDPR, then this regime will apply. This regime will be used by most data processors. Elements of Regime 1 that are different to the GDPR. Allows children aged 13 and over to give consent for information society services, for example, on-demand music, gaming and video services. Sets out when the processing of special categories of personal data and personal data relating to criminal convictions and offenses is permitted. Amends the obligations for credit reference agencies in relation to the data subject's right of access. Allows automated decision-making authorized by law. Allows processing for archiving, research and statistical purposes. Defines exemptions to rights and obligations under the Act. Makes provision for the transfer of personal data outside the EU. Regime 2. General Processing, Applied GDPR. Activities that are not dealt with by the GDPR, and are not concerned with either law enforcement or the intelligence services, are covered by the General Processing, Applied GDPR, regime. It details two main scenarios. To ensure that freedom of information rules work where public authorities hold unfiled papers and notes. To cover processing by non-law enforcement authorities or intelligence services who are processing personal data for national security or defense purposes. Regime 3. Law enforcement processing. This section sets out a separate data protection regime for authorities with law enforcement functions when they are processing for law enforcement purposes. It also applies to their processors. It implements the EU Law Enforcement Directive, LED, into UK law, and includes changes to law enforcement allowable under the LED. Regime 4. Intelligence Services Processing. National security falls outside the scope of EU law. The activities of the UK intelligence services are therefore outside the scope of the GDPR, and the LED. This section provides intelligence services with a specific data protection regime for the processing of personal data. It covers the Secret Service, MI5, Secret Intelligence Service, MI6, and the Government Communications Headquarters, GCHQ. The Information Commissioner. The DPA is enforced by the Information Commissioner. The Information Commissioner has issued a regulatory action policy, setting out how the Commissioner proposes to exercise her functions, duties and powers. DPA and GDPR enforcement. The DPA details a series of enforcement actions, designed to be applied progressively, to ensure adherence to the DPA. Information notice, requires a person to provide information to the Commissioner. Assessment notice, requires a controller or processor to submit to an assessment as to data protection compliance. Enforcement notice, requires a person to take the steps specified in the notice, or to require that a person refrains from taking certain steps. Penalty notice, requires a person to pay to the Commissioner the amount specified in the notice. Penalty amounts are in line with the GDPR, i.e. the higher of €20 million or 4% of annual worldwide turnover for serious infringements, or €10 million or 2% for other infringements. Brexit and adequacy. The UK left the EU at 11 p.m. GMT on the 31st of January 2020. The UK is no longer bound by the GDPR, which could have significant effects on the free flow of data between the UK and the EU. In order to minimize the impact on UK-EU business, the European Union Withdrawal Act 2018 sets out a framework for the future relationship between the UK and the EU. The agreement seeks to harmonize the UK and EU by using the GDPR as the basis for the DPA. Basing the DPA on the GDPR will enhance the UK's bid for adequacy, a status that means personal data can flow freely between UK and EU borders. Summary. The DPA 2018 tailors how the GDPR applies to the UK. The Act contains 4 separate data protection regimes. It forms part of the European Union Withdrawal Act 2018. We will now ask you 3 short questions. Some time will be left for you to think about the answers, however, feel free to pause the video after the question is asked to allow yourself enough time to think about the answers. The questions will be answered shortly after. Question 1. Why does the UK need a Data Protection Act? Select all that apply. A. To adapt the GDPR to apply within the UK. B. To define the exceptions adopted by the UK that are allowed by the GDPR. C. To detail the data protection responsibilities for processing not covered in the GDPR. D. To detail the data protection responsibilities of the UK intelligence services. The answer is A, B, C and D. The DPA adapts the GDPR to work with UK law, implements the derogations allowable in the regulation, covers processing not detailed in the regulation, and explains the data protection responsibilities for intelligence services. Question 2. Valerie keeps a diary in which she records details of the lives and activities of members of her church congregation. Valerie does not share her diary with anyone else. Is Valerie subject to the DPA, and should she get consent from the other parishioners to record their personal details? Yes or no? The answer is no. Neither the DPA nor the GDPR are applicable to personal data processed for personal use. Note, in this case processed means written down, or stored. Question 3. Why is the DPA 2018 based on the GDPR? Select all that apply. A. The UK already uses the GDPR, so there is no need to replace it. B. Europe would give us a monetary fine if we did not continue to adhere to it. C. It will contribute to the EU recognizing the UK as an adequate country. D. It helps UK businesses who need to move personal data across EU borders. The answer is C and D. The GDPR has strict rules around the international transfer of personal data, and applying the rules as laid down by the EU will make it easier for UK businesses to do business with the EU, and also contribute to making the UK an adequate country, which will remove all restrictions on the movement of personal data between the UK and EU. Note that whilst it is true that the UK already uses the GDPR, there is no obligation on the government to continue to use it as the basis for our data protection legislation. This is the end of our module, Data Protection Act 2018. You are now ready to take the final quiz in Module 15.